All right, good afternoon. Welcome to the Ask Two Lawyers studio from San Diego, California. Welcome, Keith.
Yeah, welcome, Stuart. Yeah, it's another beautiful sunny day in San Diego. Can't complain.
It is. And Keith, I'm very excited about the show today.
Yes, no, this is going to be fantastic.
I reached out to attorney Ron Zambrano and he got back to me and I said, hey, when can we have you on? And he was just finishing up a 5-week trial as that goes.
Yeah, that's a long one.
Wanted to get him on. I want to tell you a little bit about Ron. He's a partner at the West Coast Trial Lawyers. They specialize in employment law. He's a graduate for university. He was at the University of Southern California, and then he went to Whittier Law School. But check out some of the things that he's worked on recently. Just last week, he got a $4.25 million verdict in the Soulja Boy lawsuit. We can ask him more about that.
That's fantastic.
He's worked on cases for representing dancers that were not treated well by Lizzo, apparently. I think I got that right. And then he's worked on 3 or 4 Kanye cases. I guess Kanye keeps lawyers busy.
I would imagine.
So,
so.
I also got to watch Ron first on Popcorn's Planet. Andy Senior, I think is his name. And I was so impressed with Ron. And Ron's a little bit younger than you. And actually, he's a lot younger than you and I are. But
you don't have to rub that in.
Well, not in wisdom and experience. Okay. And he was very good at explaining things. And so I am so excited to have him. And I want to introduce him to our jury pool and have a conversation. Ron, welcome to Ask Two Lawyers.
Hi, thanks for having me on and for the very nice intro. Thank you.
Of course. So we wanted to talk to you about several things today. And the first one we wanted to get into was the new breaking news, Keith. And what's the new breaking news?
Well, it comes back to the subpoena, this elusive subpoena that we keep hearing about. And we've mapped this out. I don't even know how many times now we've talked about this. And we actually laid out all the different dates because the earliest filing that we know of is the CRD complaint happened on December 20th. New York Times article comes out on December 21st. Lively files her federal lawsuit in New York federal court on December 31st. And then in January sometime, she files a state court action in Texas called a Rule 202 action, which in Texas, you can go in and petition the court and ask the court for pre-litigation discovery, but you have to get permission using a petition. She files that in January of 2025. That subsequently gets dismissed. But you look at all those dates, you're like, well, none of them predate the New York Times article. And yet we keep being told that there's some subpoena out there that was issued to Stephanie Jones. What subpoena? Where is it? And so now it appears as though based on some news reports that are coming out, that maybe there was some case that was filed possibly in New York that provided the cover for issuing a subpoena.
And Ron, what are your thoughts about that? I know you had talked to Andy about this yesterday. Have you done anything else to look into this? What are your thoughts?
No, I've based on the questions I was getting and what Andy had told me, I think that the subpoena that exists, if it does exist prior to the filing of the Civil Rights Department complaint, the CRD complaint, is either something that was made up after Stephanie Jones gave her text messages in order to make her seem like she had to do it, or it was something she really did have to react to if it does exist. The curiosity for me is that in civil litigation, especially in these cases where in civil litigations, everybody texts, right? And everything's on your phone. And when you have a case, and I have clients who are like, I texted my boss for 3 years, I'm not going to rely on that client to carefully screenshot everything. I'm going to ask for a digital forensic copy. The curiosity of this is that no one will willingly give their phone to a party that isn't their friend and allow them to take a digital forensic copy, which gives them access to literally everything on your phone. There's no it's not a menu item where you can get the text messages of this thread. You get the text messages for your entire phone, all your pictures, all email data. There's some reserved social media data. So even if the subpoena exists, I doubt it said you have to give your phone to a digital forensic expert that will now basically, expose your entire life through your phone with you. To me, even if there is this document, she being Stephanie Jones, was clearly working, I hate to use this word, but in cahoots with the Lively team by just going, here's my phone, go ahead and take my a complete digital copy. So I personally think that she was coerced into that, because I don't think anyone would willingly do that. I wouldn't willingly do that. I just wouldn't, because it's different. Like, okay, here's some text messages with Baldoni, right? Here you go. Here's me complying. But it's a different level, because that's what this is in the CRD complaint. That's why they look like that. Those are extracts from what's called a Cellbrite report from a digital forensic copy of the phone that was extracted from her personal phone, and that is very different than screenshots.
Yeah, they're clearly not screenshots that somebody has taken.
Yeah, so I think because of the level of production, there's still, even with this prophylactic subpoena, there's still, I think, a very good argument that this was just, made up to cover up the let's call it conspiracy, I guess, to do this.
So let's say somebody files a lawsuit. Let's say I would, I want to file a lawsuit. I want to get your phone records, Ron. So I file a lawsuit against Stewart, and I file it in state court. I never serve you with the lawsuit. I don't serve Stewart with the lawsuit either. And then I just issue a subpoena. Well, I'm not suing you. I'm suing him, but I issue a subpoena to you. And so it goes to you. I mean, I guess my first question, before we even get to the mechanics of that, the first thing, just within the context of the Lively Baldoni thing, is if somebody filed a lawsuit for the purpose of issuing a subpoena, how do they know to issue the subpoena to Stephanie Jones? Why be so specific? Why issue it to her and not, I don't know, other witnesses in the case?
Because it was filed for an ulterior motive. It was filed for an ulterior motive. If there's a real lawsuit that existed prior to the CRD complaint, it was filed with an ulterior motive because it was so directed at Stephanie Jones. And the problem for Manette Phelps is that a judge may go, what else did you do with this? What else were you able to procure using this sham subpoenas or lawsuit rather? And just for the purposes of forcing or tricking people into giving you stuff, assuming it went beyond Stephanie Jones. Because that's what I would do as Friedman. I'd be like, wait a minute, if you did it with Stephanie Jones, did you do it with Jennifer Abel? Did you, who else did you give this stuff to? Because you shouldn't have done that in the first place.
I think this has given a new life to the Baldoni team, because this is something they can really dig into. And, Manette, they're a very well-respected firm, huge firm. We all know them as lawyers. And again, we want to preface this by saying if this occurred, I mean, this still needs to be developed. But if there was a sham subpoena or a subpoena that wasn't properly served or given notice to everybody or just used as a way to get a bunch of information without anybody knowing about it at the time, I think that the court's going to be pissed off about this. I think that Justin Baldoni, I think he has Wayfair, all of them, they have claims themselves against the lawyers who I feel were doing a really good job at coming after them with these privileges they were outlining in the 12B6 motions. And now it's kind of flipped the script on all of that. What are your thoughts on that?
Right. So assuming there's a sham complaint for an ulterior motive that created this subpoena, this one subpoena we know about, I believe it would lead to a finding of the district court judge saying you engage in self-help. Everybody in the country knows you do not engage with that. It could subject Manette Phelps to be, I think, if Friedman gets him pissed off enough, disqualified from the case for engaging in self-help. And that's on the high end, right? That's the most extreme thing. Maybe a more extreme thing, maybe evidentiary sanctions, but I don't think that's really on the table. Or at least some type of monetary sanction for really creating this lawsuit that was a waste of judicial resources in the first place, even though nothing happened. I mean, you still had to file it. You still took court time. They probably violated the rules by not giving notice to the consumer, because when you file a subpoena they reveal someone else's records. Well, Stephanie Jones was at that point the publicist. So she should have given notice to, Manette Phelps should have given notice to consumer, to Baldoni, like, hey, we're asking for these text messages about you. And then Stephanie Jones herself, just from an ethical standpoint, should have given notice. So there's so much shadiness going on in how clandestine this was. But I think if Friedman plays his cards right and really lines up the discovery well, that he has a shot at a motion to disqualify Manette.
Could you, for our audience, we call them the jury pool, and they're a very bright group of people. And could you walk through the idea of the kind of the fairness that's built into the system when we litigate? We want to be fair. We want to fight hard. We want to be within the bounds of the law, both ethically and legally. But But with subpoenas, there's usually this idea of fairness with notice and that kind of stuff. So could you just walk the audience through, if you're going to issue a subpoena, how does that normally work?
Sure. So subpoenas are only done when you want to get information from someone that's not a party. And because when you ask from the other party knows because you're asking them directly, like, here, counsel, I want X, Y, and Z. So when you use a subpoena, one party is trying to get information or documents from someone outside of the four corners of the complaint. And in order for there to be fairness, you have to give notice to the other side that the subpoena is being issued. Now, the timing of that can be withheld, let's suppose, for maximum effect. But there are minimum requirements of when the notice has to be done, because if Baldoni, so for instance, if they do it right, they issue a subpoena for documents from, let's say, I don't know, a bank. They're supposed to give notice to Baldoni, like, hey, we're asking for the bank records, and you have to give him enough notice so that he can file a motion to quash or a protective order in order to protect his rights, to give him a shot to protect himself. Now, when it comes to the notice requirement, there's no wiggle room for that, because if you take someone's right away to object based on privacy, burdensome harassing, all that stuff, but it's basically a privacy right. Like, do you really need this stuff? Do you really need everything? Is there a more narrow and tailored way to get what should come out versus, the shotgun method? There should be time for that to be done. And when you take that away, you're really taking away that person's due process. That's why when you're issuing subpoenas for third-party information, you have to act in good faith and be transparent. And there's little transparency so far that we see with what happened with Stephanie Jones and this pre-CRD New York complaint thing that existed or may not exist.
Yeah. Yeah, because I put myself in Baldoni's shoes. I mean, for example, if you were the attorney for Justin Baldoni and they issued a subpoena to Stephanie Jones saying, hey, we're going to subpoena all these texts and emails off of this phone for Stephanie Jones, what would you do as the attorney for Baldoni had you got notice of that type of a subpoena?
Oh, I would have filed two motions, a motion to quash and a motion for protective order, which is legalese to say, telling the judge, I want you to order this person, Stephanie Jones, not to produce anything because it violates me, Baldoni's own privacy rights. And then you can cite case law, but that's the gist of it. You want to make an order that she should not comply, because until there's an order for her not to comply, she is compelled to comply. That's what subpoena means, right? Under penalty. So you have to comply under penalty of some type of sanction. But yeah, if I were Baldoni, I would have filed both motions, motion to quash and motion protective order. I would have sent a letter to her. I would have sent, an objection to her, within the bounds of what you can say. But because it's really personal. You don't know what's in there. Do you need to have everything to be in there? You could be talking about your kids, family, wife. It's so intrusive, really. Maybe some of it is relevant to whatever claims existed in whatever lawsuit that existed, but it can't be everything.
So, Ron, if you were representing the Wayfair parties right now, as the facts exist, it appears there's either a subpoena that was filed somewhere but then not served on anybody, and that's not right, shouldn't have been used that way, or there's a subpoena that was just filled out by somebody at Manat. We hope this isn't true, and they just gave it to Stephanie Jones, and she goes, "Well, that's good enough for me. Here's all the text messages." What would you do? What would be your strategy for moving forward right now, both in the courtroom and in the courtroom of public opinion as well?
I would pick what motion I want to file, and then I would work the discovery to build that motion. And I think this is not that hard. I would subpoena Stephanie Jones. I'm like, give me everything that you got that made you give these documents to the Lively team in 2024, and I want to see it. And then you get that and you're like, okay, look at this document. Is this what you got? Yep. When did you get it? How did you get it? Okay, great. That's item one. Two, when did you produce your phone? How is it that you came? Because I very much doubt the subpoena says we want to have all the electronically stored information in your phone. I very much doubt any subpoena would say that. Why would you give that? The second, whose idea was that? Who's the expert that got it? And then do you know when it was extracted? So then you get the dates of when she was served, you get the dates of when she complied, and you get the dates of when the phone was extracted. The date of when the phone is extracted is very important in my view, because that should not be altered. And that'll give you whether or not the subpoena exists after the fact or before the fact. And two, you would get the person who did the extraction and subpoena that person and go, who told you to do that? And when were you first contacted? Give me all the emails that you got. Was it Lively's team? Was it Ryan Reynolds' team? Was it, was it just Manat? I would dig until you cannot leave any stone unturned in that timeline. Then you would use everybody that you put in a corner with regards to dates and their mindset and give it, and then make a motion. For me, the ultimate goal and the ultimate swing would be a motion to disqualify Manat. Because that would be, I mean, it'd be huge flex, right? Like, look at what I did. I built this up, and if you have the facts and you do it in good faith, you can get a judge to be like, you know what, you shouldn't have done that, Manat. You guys, I don't know what else you guys had access to that you should not have had access to. You engage in self-help. You guys are poisoned. You guys are not playing fair. There was no transparency. You did not do it by the rules. You can no longer be attorneys of record for Lively in this case. Lively, you have to get somebody else new. And that would be an enormous flex. And when if I were Friedman or the Wayfair legal team, that's the plan I would lay out.
Yeah. It also makes me wonder, in California, we have the new rule now where attorneys have to report other attorneys who are engaged in unethical behavior. And it does make you wonder, like, is there an obligation here to, if you see something like this, and if it, at first you have to find out if it's true, did this really happen? But if you were to do all the discovery that you suggested, Ron, and you find out, oh, this is actually what happened, do you think that we as attorneys would have an obligation, or the attorneys working on this case for Baldoni would have an obligation to disclose that to the state bar under the mandatory reporting requirements we now have?
If there can be reasonable confirmation that they filled out some New York form without a case existing, I would do it, right? Because that's completely unethical. I would absolutely do it under the new rules, because I call it the new Girardi rules. So many things happen because of Girardi. Some of them more annoying than others, but it should also not be abused. But I think this is a big deal, right? Like engaging in the existence of a non-existence lawsuit to coerce someone into complying something they wouldn't otherwise do is fraud, right? And I think
it really seems like it.
Yeah. So if Stephanie Jones was really lied to, she's like, I thought this was real, and it turns out it's not, then she would have her own case for fraud.
Well, and I thought about that, Ron. And so, of course, that's going to be Stephanie's position. And I almost wonder, how is the New York Times going to respond to this as well? And we don't know if there's behind the scenes tolling agreements that have been signed here. But the New York Times, if they were duped into this, and I don't know that they were, but it could have happened. But, you've been a lawyer long enough. I've been a lawyer long enough. I've seen questionable subpoenas before. It doesn't happen often, but you know it when you see it. You look at it and you go, this just doesn't feel right, doesn't look right, and you check into it. And so I wonder, what due diligence Stephanie Jones and her legal team had when they got this subpoena from some no-name case, and or if there was even a case name. And I think there had to be some questions going around in their mind.
That's a really good point. One that lends credence to the idea that she was really cooperating from the beginning, and this is really just a prophylactic to try to shield herself. Although I don't think she really engaged in any unlawful activity. I think this is one of those things, another example of she didn't have to say that. Why can't she just I just give her my phone? Right. I just gave her my phone. I just cooperated with him and I gave him my phone. I hate Baldoni. He said X. I want to, I hope that would have been, none of this would have been happening, right? But now it's this is a subpoena. Well, where's the subpoena? What do you mean, what case? No one reported a case between these two or any of these two. What do you mean? Now it became this other thing. And I believe this is another example of them deciding to do something tactically that they didn't think through the full scope of it. For instance, not giving the full threads of the text messages, very dumb tactical mistake, in my opinion. Right. That they just didn't have to do. And now we're talking about it. Now they look like maybe they were lying, and who's doing this, and the Daily Mail's involved. Like, this whole thing is so stupid. I don't know who thought of this, but it's stupid. She just could have been like, I just gave her the phone. I hated Baldoni. Boom, we're done.
Although I would agree with you, although we did see the contract between Wayfair and Jones Works, and it did have 3 pages of confidentiality in there. I mean, it went on and on and on. about confidentiality.
Oh,
And
yeah. Then you're right. Yeah. Then she would need to be compelled by subpoena in order to cooperate. Yeah.
Yes, she did. It doesn't look like she fought real hard. It is coming down. So I think this, for me, this is a watershed in this case, because it's given the Baldoni team new life. Because I felt like Blake's team had put just Brian Friedman on the ropes a bit with this 47.1, and that's really why I wanted to have you on, because I think you and I may see this differently, of course, respectfully. But the 47.1, when I saw the 12B6 that was filed, I thought it was really well done, especially all three privileges outlined that they're relying on. But really, 47.1 is the game, and that's where it's at. And I do kind of think this surprised Brian Friedman and his team. It's a relatively new law. It went into effect January 1 of 2024. I know you practice in this area. I won't put you on the spot and ask you, when did you first learn of this law? But I know that you use this law, and you'll use it for your clients more times than you won't. And I think it is a super effective law because of the damages and the overhang from those damages on the person you're suing. And it's not just attorney's fees this time, which you typically get in your SH and SA type lawsuits that you file. Maybe you can walk us through that a little bit. I know many of our many of our clients, we don't work in this area, but when they come to us and they've been sued for SH, their lawyers tell them to settle because of the attorney's fees provision. Well, here we don't just have attorney's fees, we've got treble damages and we've got punitive damages. And it's not just the 12B6 phase we're talking about. I think you and I agree we'll get through the 12B6 phase. We, Baldoni, whoever, they'll make it through that. It's just this overhang of damages and it's going to get bigger and bigger as the case goes along. And if somehow, some way, Blake Lively's the prevailing party, I know it's hard for people to even imagine that, but what if it did happen? So you weren't all that concerned, at least that's the impression I got, that 47.1 was going to be a problem. I'm sitting here going, boy, this is a problem. Help me out. Help me understand better where I've gone wrong, or if you had a come to Jesus moment where you're like, well, maybe there is something to it.
I view it in the stage that it's being brought up in. So a 12B6 motion is a demur, right? It's and you have to assume everything in the complaint is true. And Baldoni's complaint, I'll admit, I didn't read every single word. I got to like page 20. I'm like, wait, what's left? But I did breeze through it. I mean, it's what is it, like 80 something bits?
Oh, it's ridiculous. It's like 600 paragraphs.
And it's like clips of this and snapshots of that. It is. I can't imagine how many hours it took to make it, but it's very thorough. Yeah. And at the pleading stage, as you guys know, the judge has to assume everything there is true. So if there's an attack on that pleading and the judge has to make the presumption that everything there is true, then he's entitled at that point to make reasonable inferences about the defenses to 47.1, which is there enough evidence for a fact finder to see that maybe she did initially start this with malice? And I think there is, based on his complaint, assuming everything else is true. Is there enough for a fact finder to show, for a fact finder to find that she did not have a good faith basis to bring on what she put in her CRD complaint? I think, at least assuming everything is true, the story is there. So that's why I think at the 12B6 stage, I'm not really worried about it, because if the judge is being intellectually honest, which we all hope as litigators that they are, and sometimes you feel they're not. But if this particular judge is intellectually honest and is taking that role seriously and is making the presumption that everything in that complaint is true, then I think you can see from that perspective, well, a jury can see that maybe this was done maliciously. Look at what was left out. Maybe she didn't have a good faith basis. Look at the stuff that he is in his complaint that she left out. And I think for that purposes, I don't think it's a big deal. Now the lawyering has to start after that, right? The real work is past the pleading stage and doing the discovery and who comes off better before a jury. And my understanding so far in the very few interviews I've seen and what I've read is that Lively is not that likable. And that is a big problem if she's not that likable. And she will probably try to use her very likable husband as some type of shield, because he's going to be involved in this. That'd be the other thing I do as Freeman. I would absolutely get him and anyone else surrounding her life subpoenaed and try to get into this case. In a deposition. But if she's in fact what a lot of reports have shown and what she's come off in interviews, either spontaneous interviews or even not scripted interviews, but like scheduled interviews, she's not going to come off well to a jury, and she will not be, that will not help her in this whole, well, you know, I didn't do this maliciously. I did have good faith basis. I would not want to represent personally, if that were the case. You never want to represent in civil litigation someone who you think a jury is just going to be turned off by. I don't need you to love my client. I just don't need you to be turned off by her because she's just rubbing you the wrong way. And that's kind of the vibes I'm getting from her. So I am scared for her at trial, purely based on that. Because if a jury goes like, you're just not that likable. That's what happened to Amber Heard. She's not that likable. You know,
Yeah.
Johnny Depp was Johnny Depp. He looked like, you know, whatever version of Captain Jack Sparrow he was at that point, with the rings and the makeup that's not, you know, and then she just didn't do that well. She rubbed the jury the wrong way. Even though she had won in Europe, she still lost here because it's before a jury. And when you are creating a narrative, you have no control over the jury's reaction to your client. And if you know your client is going to rub the jury the wrong way, there's a possibility, you don't want to go that far. And that is a possibility, in my opinion, here. It is. It really is. She kind of comes off like not likable, and like, wow, I could see the turn of you being a little upset when you don't get things your way, and it's not going to help her.
Yeah, I mean, we've been talking too about how her deposition is going to be terrible, I think, for Blake Lively. And if I were her attorneys, I'd say you need to get out of this case before your deposition's taken, because you're going to be destroyed. But the truth remains, though, that under 47.1, so what you're saying is that ultimately you think that the jury's not going to like her and is not going to side with her, and therefore would side with Baldoni on the defamation claim. But it is true, though, that Baldoni has to live under the threat that 47.1 brings forward. And it's a much bigger threat than would be around with just Civil Code 47 litigation privilege. The 47.1 threat is just, it seems like such a huge burden to have to live under. And we've talked about it. It's kind of like having a piano hanging over your head on a very thin wire. You know, you're talking the treble damages and the punitives. I mean, that's just a massive, you know, threat hanging over your head during the whole course of this litigation. That's not easy to live under for, you know, a year or 2 years of this litigation.
It's not, but I don't think he has much to lose anymore at this point. From what I've read, he has been, but before he's punched back with Friedman, he really did suffer a lot. You know, he was fired and people were really throwing him under the bus. And he didn't know at that point what was going to happen. And he got a team that did this ridiculously long and thorough complaint. Yes, I think it is. I agree with you. This type, just like the attorney's fees, right, that Stuart was talking about, you know, in employment cases, unless there's an element of sexual assault, you know, or there's some type of egregious turning of a blind eye by the employer, which is what I do. I do employment law. The fees sometimes wag the rest of the case, right? Like, you know, well, how damaged can she be? You know, she's only 20. You're like, well, that's nice, but through trial, you're going to get a 7-figure fee motion, so maybe you should rethink that. And it does wag the case, right? It is the tail wagging the dog. So I agree with you. This is something that is very, very, it's a big stick over his head for the pendency of litigation. But from a trial perspective, he also gets to go and argue that she was acting maliciously. So at trial, there's going to be an argument. Well, when the jury is asked to answer the question, if Lively was acting with malice with regards to defamation, are they also answering the question for the 47.1 question? And then everyone's like, well, we're going to confuse the jury. We're like, well, this is going to confuse the jury no matter what. And that's going to be a fight before trial even starts. The other thing the judge has to figure out, a New York judge, is figure out, like, am I supposed to answer this? You know, maybe on a Rule 56 motion, the motion for summary judgment. Is that my decision?
Or the Supreme Court of California.
Yeah, I know. Like, because it's so new. Like, is it a legal question or is it a factual question? It sounds like a factual question because it's, you know, because this really is so new. But let's suppose it gets past that point. Well, Baldoni's like, I will get on Alice because they're going to answer one question, right? They're going to answer, did she act maliciously and how she did the CRD complaint and she published it even though it was supposed to be private, and then somehow it got to the New York Times and then it was published again. I'm happy to make that argument, and I think I'll get that argument. That's why I don't know these people. I wasn't there. I haven't read everything, but from a legal perspective, I'd rather be on Baldoni's side.
I agree with that. It's just that this seems to be what the statute was squarely written for, and that is somebody coming forward and claiming that SH has taken place and somebody getting pissed off about that, which nobody likes to be told that they were involved in SH. And then they say, well, I'm going to come after her with a defamation claim, and I've got resources and I've got money. And obviously, I think the thing that really bothers many of the people in our audience is, yeah, but Blake Lively's famous. She's got money. She doesn't need this statute. It's really an unfair advantage. And I just wanted to say, well, welcome to California, where the legislature legislates just about everything we do. And guys like you, I mean, you're a very good lawyer. I'm not going to take that away from you, but I do feel like there's a little bit of an advantage when you're on the plaintiff side of these cases, where it's just a one-way attorney's fee provision in the statute. It's a great way to, I love how you said to wag the dog. It's a great way to be in mediation and say, hey, yeah, you're right. She's 20. You think that this wasn't a big deal. But when you're facing, a couple $1 million in attorney's fees on top of what you're going to pay her, all of a sudden you come to your senses and you resolve the case. And that was my concern for Team Baldoni. And it made me also think that, this is an albatross around their neck, and they really have a great claim against Ryan Reynolds, in my opinion. And he's a really deep pocket. Go after him, put everything in your sights after him, and then defend yourself vehemently. A lot of people are confused and thinking that if Baldoni and Wafer hadn't filed a defamation claim, they think that he can't defend himself somehow against the SH claims that Lively brought. No, he can defend himself strongly, and it allows him to come out with full force. It narrows the issues for the jury, so there's no confusion with it. Well, there's going to be confusion in this case, but less confusion. And that was the only thing I was thinking about. And I wondered, did Brian Friedman and his team, and I don't want to, these are wonderful lawyers. These are awesome lawyers, way better than I'll ever be. But did they really appreciate and understand what 47.1 was going to do? It kind of ties their hand behind their back. But thank God, now they've got this new sham subpoena issue. And I think it does reinvigorate the case.
So yeah, listen, I learned about 47.1 in I'm part of CELA, the California Employment Lawyers Association. When they do this at the end of the conference, and like, this is the new stuff coming up next year. And I didn't remember it past that point until like, oh yeah, there's this thing that exists that's really cool. And I think it is important. The funny thing is that, and I don't know if anyone's talked about this, what this really is, it's an anti-SLAPP motion, right?
Yep. Mm-hmm. Yep.
It's really, and for those of people listening, anti-SLAPP is when you, it's SLAPP, strategic lawsuit against protected, I forget, you guys know
participation. Public participation.
Yeah. Thank you. So, and I've dealt with a lot of those. The Lizzo case, for instance, I had to deal with that. She filed a SLAPP statute saying everything she does on tour is protected by her free speech amendment. We got past that. She appealed that. But to me, when I saw this, like, this is really a SLAPP motion, really. Like, you're saying you're coming after me for something that is protected. My protected activity is bringing up these claims of harassment or sexual, whatever it was, harassment here. The thing is that there are always caveats in trying to evoke these protections. And so for the anti-SLAPP motion, which is you go, hey, I'm gonna tell you, a person who just told me I did something wrong based on my protected activity. It's my protected activity. You just walked into a briar patch. I'm gonna get your complaint dismissed. I win. And 2, you're gonna have to pay for my entire attorney's fees. 47.1 is just this, like, on steroids, right?
Yes.
That's what really what it is. And it through statutory language, it includes something beyond the 4 categories, which are these very broad categories. The legislature just said, listen, a complaint of harassment, whether it's filed or not, is protected activity, and we're going to give it a special treatment, but it's really a form of anti-SLAPP, which I think is great. But even then, in an anti-SLAPP motion, you can defend yourself, going like, this is my entire case. This is why I'm going to win. This is why, yes, it might touch upon someone's protected activity, but just because it's protected doesn't mean it's absolute. There are no absolutes other than the attorney-client privilege, really. There are really no absolutes. So you have to act in good faith. And here, the legislature decided, we're going to put the words maliciousness and good faith. And if those 2 things are met, by the person that are that's trying to get away from the liability of 47.1, then they shouldn't have done that. I agree with you. This is a very good law and it should exist. And there's a lot of abuse and trying to silence a lot of victims. But there is this built in, like, you have to be done in good faith and you can't do it maliciously. And I think Baldoni can do it here. I think he can reach that.
But the problem I have with 47.1 versus anti-SLAPP comes with the treble damages and the punitive damages. And so if it's just attorney's fees, I could see your point, and I do think it's a good law in a vast majority of cases, even though obviously this is a case where it's being used in a way that we don't like and we don't think is necessary. But man, the treble damages and punitives, I wonder if that is unconstitutional. I feel like that is just a really big step in the wrong direction for 47.1.
I agree with you. I think it's an overstep as far as the recovery is. I think treble damages and punitive, I think both of them together is like this, what do you call it, the poison pill of things. Like I think it is too much, and I think it will be at least looked at as unconstitutional. But for right now, a New York judge isn't going to say that. Like the New York judge is like, I'm going to punt. I'm not going to punt it. Maybe my court of appeal will punt it back over, but I'm not going to call it unconstitutional. I just don't see it happening. So they have to deal with it until it's over.
Right.
So Ron, I don't know how much time you've spent on this case, but we've spent too much time and we've not been able to bill a penny for it. In fact, we've had to lose money on the case, but you sound like you know the facts pretty well. But I'm just curious from your standpoint, why is the public so interested in this case? It's just taken a life of its own. Every twist and turn is analyzed. People want to watch every single lawyer opine on this. I mean, people are really into the boring part of this case even. So what's going on? I mean, can you explain this?
I think it's part of the outgrowth of the Me Too movement. I think it's an outgrowth of people, the kind of the widespread news of just celebrity cases. We have Diddy. We had the whole Busby Dre thing. We have, for those of other nerds, the Girardi thing, the Johnny Depp thing, the Amber Heard. I think this is part of the Amber Heard, whatever Amber Heard and Johnny Depp track was, this is another stop in that. And I think people are interested in that sense. And I think the other thing is that there's such publicly available things in the complaints that are so private. You could read the text messages, you could read these emails, and there's a Hollywood component to it. And then Ryan Reynolds is this elephant in the room who has his own brand, who really, I think up to this point was doing great, but now he's being a little bit affected in a negative light by what his wife is doing or trying to do. And now he's defending himself. And now it's this, and then we're all being reminded that they met each other by cheating with whoever they were at the time. And I think it's just this confluence of things that people are like, where's this going? But really at the end of the day, you can see these very detailed exchanges where people can read on their own, like, oh my God, this text message followed by this email, I can see it this way. And oh my God, over here, they omitted that. Why did they do that? And I think that's why people are so invested. It's this ability to not require lawyers really to read the complaint, because typically you know how the complaints are, like it's a bunch of it's 100 paragraphs and 3 of them might be facts. Like, well, that wasn't this case. And I think that's why people can engage in it, because they could see it for themselves. And then the Amber Heard thing, and then the Ryan Reynolds thing, and it's this own life really. And it did coincide with the Netflix thing. I told my wife, like, this is just a sham to get people to watch because now you're watching. But I was wrong. I was wrong on that. So I eat my words on that one.
It is funny because we've been saying, like I said earlier, that the Baldoni complaint is ridiculous. And what we mean by that as lawyers is the length of it. It's just so long and so loaded with facts that as lawyers, that is not what you see in complaints. Complaints are usually very dry, very boring. And then the Exhibit A attached to Baldoni's complaint, just a whole host of just texts and emails. And
I actually enjoyed Exhibit A. It was like a book. I couldn't put it down.
I know, it was the greatest. And so I think you're right, Ron. I think that people, I think this case is accessible from a factual basis very early on in a way that most cases aren't. And then you have the legal part. And I've said multiple times that if you want to learn the law, there's a great case to learn it because it's got everything. It's complex. It's got federal court. It's got state court. This is a great primer on the law, and it is complex, even for us as lawyers going through all this stuff. There's a lot going on and a lot to try to figure out.
Yeah, we've had to dust off our federal rules of civil procedure from
I
law
know.
school all the way back in law school. So we make it up to federal court
I
like
know.
once a year. So we don't know what we're doing. But Ron, I have one more question for you, and Keith may have another. And it's a little bit of an unfair question, but it just gives me great pleasure to give it to you because it's so unfair. And that is,
Okay.
do you think this case settles, or do you think it goes all the way to trial?
That's not an unfair question. I think it should settle, but there's only one path. Is that someone has to convince Lively's team that she has to do a sequel, bring him back on, give him the PGA back, and somehow without losing face say, we have differing opinions, but we're all trying to succeed and we're all better for it and we'll all learn. I think that would be the best way to do it. If she doesn't do something like that, and assuming nothing terrible comes up that would make Friedman go to Baldoni like, you cannot try this case, I would try the case. There's no amount of money outside of really an act of goodwill, like doing a sequel and kind of eating words without eating words. Outside of that, I would just try the case.
If you were on Baldoni's side, you would try the case. Okay,
I would
but now
absolutely try the case.
Now you're on Lively's side. Would you try the case?
No, for two reasons. One, I don't think she'll do well in front of a jury. I agree with you guys that she should settle before she's even deposed. I'm sure there's a protective order so that the video doesn't come out, unless it's part of shown at trial. But I don't think she'll. I just don't think she'll. I don't know her personally. This is based on an hour worth of interviews and articles. But from what I understand, based on that 1 hour, she just doesn't come off well in a way that she can connect with a jury that would empathize with her. And that's what you need when you're going in trial. The minute I've told my clients before, like, I want to go to trial. I'm sorry, you're a jerk. They're not going to like you. I have to tell you that. Because if I don't tell you that and you lose a trial, you're going to be mad at me, going like, well, why didn't you tell me? They always blame the attorney. I'm going to tell you now. You're not going to do well at trial. I'm going to put it in writing, and if you ignore it, that's fine. But you have to be honest. You have to be honest. You can't like lead on your own client if you're putting him down to a road that they're going to fail. But Lively's going to be like, well, just throw money at him. I don't think he'll take money. He's like, I need more than money. And I think, and that's what I would tell about it. He's not going to take just money. He's going to want something that is a form of contrition. And you better tell Lively, you better figure it out how this contrition so that you walk away from this unscathed. I don't think she'll resonate with a jury in a positive. I don't, and they have to avoid it.
But there is a path to settlement. I mean, if it is contrition, and I agree with you, there has to be some contrition. I don't see Baldoni just saying, give me X amount and I'm good. There's going to have to be something. It's an interesting thought that you bring up though about, they do a sequel. And
wait, would they be kissing in the sequel? Like these two people that want to kill each other right now?
Well, they're both good actors. But the thing that I find interesting about that is that it provides contrition, but it also provides a path of maybe rehabilitation for Lively, which she's going to want some way, somehow out of this. I don't know how you get out of this and rehabilitate her at this point, but that's what she would want. And if I was Lively's attorneys, I would be jumping up and down telling her, settle before you get deposed. And I would say it so many times, they probably would fire me, but I wouldn't care. Like that's how important I think it would be for her to hear it.
Yeah, I think at a time like this, there needs to be somebody on each team, and probably needs to be Lively's team that does the reaching out, where they're reaching out to the other side and saying, hey, can I just go to dinner with you? And can we talk about our kids? Can we talk about anything but this case? But then slowly let's start talking about this case, because if they can resolve this, there is a path forward. I do think that if people came out, if Lively came out and made a heartfelt apology, I'm sure Ryan Reynolds would have to be included in that for the predator statements and those kinds of things. If they could humble themselves to do that, it'd be a very humbling moment. But I think people would admire them at the same time. I feel like the American people are very forgiving. I feel like people want winners. And if people were to come out and admit they're wrong, take responsibility. When I've argued in front of a jury, I've always pointed to the defendant and say, they haven't taken responsibility. They've forced us to 5 years to come and sit here in front of you folks, take you away from your families and friends. And all we're asking you to do is hold them responsible because they won't. And then we walk through what responsibility is. If Blake would do that, if she would take responsibility, if Ryan Reynolds would take responsibility, I would have huge respect for them. And then I think that gives Baldoni what he wants, because his name has been impacted so harshly. You can't think of worse words that somebody could say about somebody else. And I hadn't thought about the sequel, but it's starting to grow on me, because what that would show is both sides are coming together. They truly have forgiven and forgotten. Did I say that correctly?
Yeah, I think so.
And now they're going to do some type of a sequel together, which I would actually watch, and I wouldn't watch these kind of movies normally speaking. So that's a really interesting idea.
Yeah, to go to the point of what I think the American public would like is to see grown-ups learn from their mistakes and move forward in a positive way versus staying on polarizing sides, which I think people are craving, right? People are craving a sense of, I'm not always right. I can make mistakes. I can do better. You can do better. Let's do better together. I think that's something that would be powerful. I think it would help both sides, really. And I think it would be such a refreshing thing in this environment that we're in. I think everybody wins with a sequel if it's, structured in a way where no one is getting, too raked over the coals. And I think it's the best resolution for both of them, in my opinion.
Yeah. Well, Ron, you pulled that together nicely at the end here. We have just a few minutes left. I know you have a hard stop coming up here in about 10 minutes, but Eric, did we have any questions for Ron?
Yeah, Ron was getting some awesome feedback. People are saying Ron's awesome, and Ron is explaining this really well for my 5-year-old brain. And well, Jules was saying no sequel, please. So I think there's a lot of people who are kind of saying that.
And she paid to say that. So I mean, that she really feels strongly about that.
Here was one I wanted to get to that someone had mentioned from last stream, but they said, here's a gist. Seems like this jury pool member did their homework. Doesn't disclosing private texts, PC 637, break the fair reporting privilege, exception C. Do you guys have any opinions on this?
I do, if you don't, Ron.
I'll let you lead the way. I'm not really sure what's being referred to.
Yeah, I think the reporting privilege has a little hole in it, where there's communications that are outside of some type of a court proceeding or administrative proceeding or something like that. And my view of it is that 47.1 covers all those holes up, because it says whether the thing is filed or not, you can communicate these things to somebody else. So if we were just talking about the fair reporting privilege or the litigation privilege, I think that there's going to be some problems with all of these things that were looked at, the thousands of texts that Keith's talked about over and over again, that had nothing to do with the CRD complaint because it hadn't been filed yet. So I think that's the hole for those two privileges. But 47.1 comes to save the day.
And I think the New York Times would still be covered by the fair reporting privilege, because their position, I'm sure, is going to be, we were told this was a subpoena. How are we supposed to know? And it was already in the CRD complaint by the time we got it. It would be their story, I would think.
Ron, I'm glad we could have you on so that Keith and I could answer your questions. Is there anything else for Ron, Eric?
Not too much. I mean, it seems like you guys, there was a bunch of chats, and we appreciate everyone tuning in and contributing. JT was wondering, have you guys ever worked on a case with Ron before? What would that look like?
Well, he would beat us. I have to say, Ron would beat us.
No, but we could co-counsel. If we're on the same
we can
side,
co-counsel. Why not?
Yeah.
Well, we're not defense lawyers, so chances are we would be on the same side.
Well, are you on the plaintiff side a lot, Ron? Or
only plaintiffs? I only represent
only plaintiffs.
That's all I do.
Yeah.
That's all I do. Yep. And just to quickly, I have my own thoughts about the fair reporting in the New York Times.
Sure.
As you've seen, I've done some cases that people want to report as they're about to be published. As about to be filed. I've spoken to editors and lawyers for not the maybe the New York Times, but other very highly respected, and they ask you very direct questions about, is this something that everybody's going to have access to? Are they supposed to have access to this? Where did you get this information? And I would be very surprised if someone from the New York Times didn't have that conversation with someone in Lively's team about, am I about to report something that can be publicly accessible to everyone else or not? Because if the answer is no, they probably would not have done the story. They would not have done the story. Oh yeah. They would not have done the story. They're like, wait a minute, you're giving us something that we're not supposed to have outside of the CRD process. They would not have done the story, because then they become part of what has happened, right? Like, wait a minute, what are we being exposed to? Is it really fair reporting if no one else can have access to it? That's the problem.
So they probably did ask the question. They probably were told, yes, there is a subpoena. And they're like, oh, okay, well, it's a subpoena. So be it. I mean, they don't have to go out and, 1000% double check that. If they're told it was a subpoena, they have the right to rely on that representation, I would think.
Exactly. Yes. But I'm positive the questions were asked directly and that things were omitted. I'm very positive. I'd be shocked. I'd be shocked if those questions weren't asked because they're always asked of me.
I mean, this whole subpoena thing is so interesting. And Ron, if you'd be willing, we'd love to have you back once we get more information about the subpoena and get to the bottom of this, and we can hash it out some more.
Yeah, Ron, we've only spent about an hour with you, and we're not quite ready for Zambrano, Albertson, and Davidson, but we would definitely love to have you back. And very insightful. I really enjoy your commentary on the case. And if you're willing to come back, I'm sure the audience would love to have you as well.
Yeah, I love the discussion. You guys are great.
All right, we'll see you next time. Thanks for coming onto our show.
Thanks for having me.
All right, thank you.
Thanks, Ron.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldavlaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.